everyone. It's Melanie Colley here, your Carolina Realtor. Easy for me to say, right? As you know, I'm a realtor with Keller Williams here in Mooresville. I am the head of the Melanie Colley Realty International team, and I'm here with Alan Guffy, and we're just going to have a conversation today about what you do. All right, so let's just dive right in. First of all, just tell me a little bit about yourself.
Okay. I'm an attorney here at Jones Childers, Johnson & Webb. Mm-hmm. I've been here about 5 years now.
Okay.
And I practice in the estate planning, administration, and real estate practice areas, along with some commercial work.
Okay.
Corporate work.
All right, and do you see much crossover in all those areas?
Yeah, and actually having some, toes in each different area is helpful when you have that crossover, because I especially see a lot of issues that come up with inherited real estate in estate situations. I do a lot of trusts, and so knowing what to do in cases of real estate that's been inherited by a minor, where you have a guardian involved, where you have a incompetent family member who needs to sign off on the deed. Having some experience in the estate section really helps, smooth through that, and so that's been a big boon to me.
That's actually pretty awesome, because I have a client in that same situation right now, so we'll talk about that.
Okay.
All right, and so what about probate? What is probate estate administration? What is that?
Yeah. So estate administration, the way I've kind of settled on telling people about it is that it's pretty much the court process that transfers property out of the name of someone who's passed away into the name of their beneficiaries. But it's sort of like bankruptcy in the sense where not only is it just retitling the property, but it's also making sure that that property is first used to pay any debts of the person that passed away. And if there's not enough money to pay all the debts, there's an order that the debts are paid. So probate is that process is overseen by the county where you pass away, by the clerk of Superior Court.
Okay.
And when I do planning, one thing that I try to do is make sure that we talk about what property is going to be subject to probate and what property is not. Because you have a lot of times where folks will have joint bank accounts, they'll have, stocks or policies that have beneficiaries on them, and these pay on death or transfer on death accounts, jointly owned accounts that have rights of survivorship, those don't go by the will, they go based on what the account says. And yeah, so we talk about that, and real estate is also treated a little differently than other types of property, because ownership in the real estate vests in the beneficiaries when the will is probated. And so if you have a property that is left to 3 people, and one of those people is the person in charge of the estate, that person may start paying all the bills, but a lot of times the court is not going to sign off on them reimbursing themselves for those expenses, because they see the property as already belonging to all 3 of those people. The estate essentially has a lien on the property if it needs to use the property to pay off debts. But if there's enough cash in the estate, then that's supposed to be used first.
Interesting. So if you have a house that is owned by somebody many years ago, mm-hmm. They got married in that house, they raised their family in that house, they died in that house, and it passed over to the kids. And now only one kid is left in that house and has remarried and brought in a husband. Mm-hmm. But it's still not in her name, it's still in.
Yeah, so one of the confusing things I think about that is that North Carolina is typically what's considered a race state, where title is really set out in what's recorded at the Register of Deeds, and the first thing that gets recorded, I sign a deed to you and sign a deed to somebody else. first person to get up to the courthouse and get it recorded has it.
I see. Okay.
So that's the idea behind the breaks. But it's not really that way for inherited property.
Okay.
There's not going to be a new deed. There can be, but there's not oftentimes a deed recorded conveying property from the deceased person to the beneficiaries. And a lot of states you'll see what's called a deed of distribution, where you'll have a deed signed by the executor of the estate conveying the property out to the beneficiaries, as the, which sort of assumes that the property went into the deceased person's estate, and then the executor is releasing that property. People don't do that in North Carolina because title just automatically, by operation of law, was vested in the beneficiaries. But because of that, there's no, there can be big gaps in the chain of title if you're just going by the register of deeds.
Right.
And the other issue that you come up with is that the tax office a lot of times will rely on some of the court paperwork, and depending on the county and depending on who's doing it, sometimes they'll get stuff a little wrong, and it'll take working with the tax office to explain, because they may not have access to the will, and if the will says something more complicated than splitting everything between these three beneficiaries, you may have more nuance to the ownership than you can really show in one line on the GIS listing.
Okay. Well, that helps out. That's another one that we'll talk about. So that's kind of what we just talked about, inheriting real estate. What other issues have you seen with inheritance of real estate?
The issues that come up, the biggest problem are when you have to have the property sold in order to pay debts of the estate. Because a lot of times people will assume they can just list it and sell it, but because the estate doesn't own it and the property is owned by several people potentially, there's a court process involved in vetting whether or not it really needs to happen. So if let's say that I and my sister have inherited the property, I'm the executor of the estate. My sister lives out of state. She technically owns half of the property, but I've been maintaining it and treating it just as I have all the other property, and I go ahead and list it. And we get an attorney to do closing, and at the closing, my sister signs a deed saying that she's okay with conveying the property. I sign the deed as the beneficiary, the executor. They sell it. The attorney's office doing the closing then distributes the money out to the estate. If that happens that way without having anything else happen, the clerk of court's office is going to require some sort of remedial agreement, or they're going to slap you on the wrist, because hopefully no more than that, because you really are supposed to do a special proceeding. So there's a process in the statutes that says that because my sister has an interest in this property, in this hypothetical, she's entitled to half of it.
Right.
And so if I'm going to have that money go into the estate and be subject to paying debts, where she's potentially not going to get half the value of the property, it's not enough for her just to sign the deed. There has to be a hearing where she is noticed, and I present evidence to the court to say that this is why it's in the best interest of the estate to have this money added to the estate in order to pay debts. And the court has to find that in favor of that. It comes up more when you have a more complicated situation. So let's say that you have a house that's left to 3 people, and then whatever's left in the estate would be left to 5 people. And they're not all the same. You start to have more complicated situations where, because the beneficiaries of the cash in the estate are not the same people as who own the house, having these hearings is important to make sure everybody's rights are represented.
Okay, that sounds like a long, drawn-out process.
Well, it can be a little longer than people want it to be because the process that is set out for us requires us to do a hearing, and then the contract, after it gets approved, has to have an upset bid period, just like a foreclosure sale. So that, it's not usually the end of the, usually I've never had one that actually got upset. And it would, in theory, be good for the estate if it did, but it's just an extra hoop to jump through that can seem like a unnecessary formality and be a frustration.
Right. Okay, well, we're going to talk for sure. So if a loved one dies and left the property in the will, does it actually, I know you answered this, but for plain folk like me, does it actually have to go through probate? So if there's a will,
so that,
and if it's a straightforward, just
if it's all right, there's a few answers to that.
Okay.
If you have a husband and wife and they're on the title together, there's going to be a right of survivorship and nothing has to happen.
Right.
It's going to be automatic.
Right.
Same with any kind of deed with a life estate or joint tenants with rights of survivorship. All that happens automatic. You don't have to do anything with the probate court. If you have a will and the only property that would be subject to probate is this piece of real estate. Let's say the person had everything, they only had cash and land, and the cash is all in a joint bank account with their only child, and they have a will that leaves everything to their only child, and the land is the only thing there. The child can do something called a probate without administration, where you can file the will with the court and not be appointed as executor. Now, you do have to probate the will because in some cases the heirs of the person may be different than the beneficiary of the will. And if you don't probate the will, North Carolina law says if there was no will, if there is no probated will, title vests in the heirs on the person's death. So a will would have to be probated, and probating doesn't just mean filing it with the county, it means having it reviewed by the clerk's office, vetted to make sure it's a valid will, and then they'll enter a certificate of probate. So you can do it without administration, but if you're going to sell the property, in order to convey clear title, you have to run a notice in the newspaper, and you would need to be qualified as an executor to sign the deed.
I see.
Because the executor has to release that lien that the estate potentially has against it. So you could do the administration without probate, and that would transfer ownership, but you'd still have to hold on to the ownership for 2 years before you could sell it, unless you wanted to go through that other process.
So more hoops.
Yeah.
Lots and lots of hoops. So we'll just call you this.
Right.
Hookah. Okay. And so that's why it's important to have a will. It's important why it's important to have things filed.
Yeah. It's important to be aware of some of this stuff and to address it up front, because there's all kinds of issues that can arise, especially, I'll give an example for if you own a condo in Myrtle Beach, you live in North Carolina, you own a piece of real estate in Myrtle Beach or South Carolina or any other state, your will work in that other state, it'll convey the property, but you're going to have to probate your will in the state where you lived at the time of your death, and you're going to have to probably open up another estate in the state where the land is located. It's called an ancillary estate.
Oh goodness, okay.
Yeah, so there are ways around that, and usually I would recommend using a trust to get around that.
Okay.
And so that's one way to minimize some of the hoops you have to go through using trusts and other strategies.
Okay. Well, that makes sense. So what is a trust?
Yeah, so a trust, that is an agreement between you and your trustee to hold property for you, subject to sort of some rules that you put in place. And you can make yourself the trustee during your lifetime, as long as you have something happen to that property after you pass away and a successor trustee.
Okay.
So you can set up a trust for yourself, for your own property that you have access to, and then have it say that, well, when I pass away, I want my children to get the property, and I'm going to name my oldest child as the trustee, and that will satisfy those requirements. And because the trust can be governed by the laws here, you can transfer ownership that way without having to go through that ancillary administration process.
So for our elderly folks, where some of them live in Florida half the year, some of them live in New York half the year, let's say they're in Florida and they pass in Florida, but they have their estate in New York.
Yeah.
So that's where that comes in, where you have to.
Yeah. So if you're the estate gets probated in your state of residence. So if you live in New York and you're vacationing in Florida and have a vacation house in Florida, you still have the estate probated in New York.
Right.
Or North Carolina in this case.
So long as you're appointing one as your primary residence and the other one as your.
Right.
You know, 6 months out of the year.
Right. If it's 6 months out of the year, you look at things like, well, where do they have a driver's license?
Right.
Where do they file taxes? Do they have any kind of claim of a certain residence for tax purposes? Where they spend most of their time is important. Where is their mailing address? What mailing address is listed on all their property tax bills? You look at all that stuff, and it's all sort of weighed, and you kind of consider all those things when you figure out which ones.
Okay. Well, makes sense. We have a lot of Northeasterners that come here. Florida's too hot, so they come to North Carolina, halfway there, and they still go back up to New York, for the hot seasons. And it would make sense for them to hear this, because obviously, where they. And I guess too, there might be tax benefits if you claim one state over the other state.
Yeah, potentially.
Yeah.
Potentially, I don't. It could be.
I know. I get. Well, right. They need to talk to an accountant.
Yeah,
I get that. Yeah. Okay. Does everybody need a trust?
No, I don't think everybody needs one.
Okay.
If you don't have one, you will have to go through the probate process, possibly.
Right.
But it could be, fairly easy, and it really depends on what you own, how you own the assets you have, and your own situation. So most of the people that I do trust for are doing trust either because they want to avoid probate or minimize the probate process. Maybe they have assets out of state, like land out of state. Maybe they have, a bad experience probating a family member's estate, or sometimes they have children that are younger and they have a lot of assets. They're fortunate to acquire a lot of assets that they don't want their child or young adult child to have right away.
Right.
So they may have, $2 million and a 20-year-old, and they don't think it's a good idea for the 20-year-old just to get $2 million if something happened to them. And so they'll set up trust for that. Trust give you control over that sort of thing.
Okay.
But a lot of times, if you are, have adult mature children, and most of your assets are transferable on death by retirement accounts or life insurance.
Right.
There may not be that much property that actually is going through probate. I will say that the cost of probate, in terms of what the court charges, is not as bad in North Carolina as it is in a lot of other states.
Okay.
North Carolina charges 40 cents for every $100 worth of probate property, and it's capped. So there's a $6,000 cap on the probate fees that sort of mitigates how much expense you'll have to go through. Now that's assuming that you're doing it on your own. You still have to go through the court audit process until if you're paying an attorney, that's on top of that. But as far as the court fees go, it's not as bad as some places.
Okay. Still worth it probably in the end.
Yeah, so everybody's different, and when I draw up a trust for somebody, it's usually something that I've talked to them about, making sure they know why they're getting it. I feel like, if you go to an attorney and you get sold a bunch of documents and you put it in a drawer and you have no idea what you got, then you have not been well served.
Right.
So I think it's real important that people that do go for a trust know why they're doing it and know what it's accomplishing for them.
Okay. Well, let's see. We've talked about out-of-state real estate. Well, here's one. Trust ancillary administration out-of-state real estate. What is different about out-of-state real estate?
Yeah. So that's where I was talking about having a piece of property, like a vacation house in another state. You're not able to probate the will one time. You have to actually open an estate here and then go into that other state and open an estate there. And each state has its own laws surrounding how a ancillary administration would be treated.
And would that go for businesses as well? Let's say,
So North Carolina treats like the ownership interest in a business as personal property. So if you own an LLC, even if it's a South Carolina LLC that's organized in South Carolina, the ownership interest is considered a piece of personal property. So it would be probated up here, and the ownership interest would be transferred through the estate up here. And I don't believe you'd have to do an ancillary estate. I have to double check.
Right,
I've not had that come up actually.
Okay.
But I think that would not be an issue. So the ownership would transfer, but the real estate would not really change hands.
Right.
Because the real estate is going to still stay the property of that LLC.
Right.
It's just the ownership of the LLC
Right.
changes.
Makes sense. Okay. And define ancillary administration.
That's just the estate, the name of the estate and the other state. So
The estate.
Yes, like a subsidiary estate.
Okay. And it says discuss how trusts can avoid them. How?
Yeah. So if you are setting up a trust and you have the property owned by that trust, then it's not going to be you don't have to probate it anymore.
Okay.
So if it's owned by the trust is going to pass outside of probate, and ownership will just transfer the way the trust says. There may be catches on that. So every state may have different rules about how to make sure that you transfer clear title. And if the trust owns it, but there is a rule that you have to publish a notice of creditors in the newspaper or something like that, that could complicate things if you plan on selling it.
Right.
But most states have a kind of clear window of time that you have to worry about that, and after that window passes, you can freely sell the property without going through anything else. I had that happen one time with a family that had inherited property in South Carolina. I actually have a South Carolina license.
Okay. That's why.
Yeah. Wonderful. Yeah, I'm from South Carolina. And,
I didn't know that.
Yeah,
okay.
I'm from South Carolina.
Gosh, all this time I didn't know that.
Yeah, no, I grew up in Camden, near Columbia, and I actually worked in the Charleston area before I moved up here. The probate window in South Carolina is a little different than it is up here, and it's simpler, I think, but in some ways it's like 1 year period instead of having sort of varying windows.
Okay, so we don't want to take much time because we're going to lose people. Can you just summarize what it is you do, the importance of things that you do, and how people can reach you?
Sure. So I do estate planning, estate administration. I do some business and real estate work. Most of it related to estates. I also do guardianships and do some advising on special needs trusts and Medicaid. my phone number here at Jones Childers is 704-664-1127. You call up here and they will get you in the office to see me, and I'm happy to meet with anybody that has questions about this stuff, and we can talk about your specific issues and come up with a plan to help you address it.
Okay, that's awesome. Well, thank you. I appreciate it.
Absolutely.
Awesome.